Okay, good afternoon and welcome everyone. My name is Joseph Kearney and it's a great privilege for me as Dean of Marquette University Law School to introduce our annual Nies lecture. We are very grateful and delighted that all of you are with us today. Let me begin by recalling the person in whose memory this lecture stands. The law school created this annual lecture series in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit. Judge Nies continues to be widely remembered within the intellectual property community as a very generous individual and a hardworking, accomplished, and modest judge. The idea for the lecture came from Professor Craig Nard, whom we were fortunate to have on our faculty at the time. We are no less fortunate today with Professors Bruce Boyden and Kaylee Murray serving as co-directors of our intellectual property program. They lead us not only generally in this realm with a relentless and impressive focus on our students, but also in helping ensure that annually we host a distinguished lecturer in IP. This year's Nies lecturer has wide-ranging interests and expertise in intellectual property. Mark McKenna is the John P. Murphy Foundation Professor at Notre Dame Law School. Beyond his home base in South Bend, he has an international profile, having taught from time to time at other prominent law schools, both in the United States and in cities such as Toronto, Munich, and Turin. His writing, itself a form of teaching, has appeared in multiple books, including one that he has co-authored with Craig Nard, I must note, and in law reviews including the University of Pennsylvania, William and Mary, Georgetown, Michigan, and Stanford, to name only some of the more recent ones. The topics of Professor McKenna's teaching and writing range widely, encompassing nearly every area of intellectual property law, including patent, copyright, and the right of publicity. Yet his central interest, without doubt, his area of particular expertise involves trademarks. So I'm delighted that it is this topic that Professor McKenna has elected to take up today in a Nies lecture titled The Rise of Property and Decline of Equity in Trademark Law. Won't you please join me in welcoming to Marquette University Law School for this year's Helen Wilson Nies lecture, Professor Mark McKenna.
Okay, so I'm told I didn't have to do anything to turn the mic on. Everybody hears me okay? All right, great. Well, I'm having begun my career teaching in St. Louis, I'm especially grateful to all of you for being here on opening day, especially when I realized at lunchtime that they were playing the Cardinals. I can just tell you from my teaching experience in St. Louis that on opening day in St. Louis, no one would have been here. They would have all been there. So let me just begin by thanking Dean Kearney and Bruce and Kaylee for inviting me to give this lecture. It's a wonderful privilege to get a chance to give a lecture named after Judge Helen Nies. And I'm particularly humbled to have been asked to join what is a really incredible group of eminent scholars and practitioners who have given this lecture over the years. My talk today is going to focus on the relationship between trademark and unfair competition law. And as I was preparing that talk, I was really delighted to learn about Judge Nies's career as a trademark practitioner. Like many of you, I had been quite familiar with Judge Nies and her contributions to patent law. And obviously, she sat on a court that considers a number of important trademark issues. But I learned from Graham Dinwiddie's 2004 Nies lecture that for approximately 20 years prior to her judicial service, Helen Nies was a prominent practitioner of trademark law and even was an advisor to the Restatement Third of Unfair Competition, which was published in 1995, shortly before she passed away. So I'm really happy that the topic I'm going to discuss today is an appropriate fit with this lecture, and if I have counted correctly, only the second time a trademark lecture has ever been given in this series. So as I alluded to before, I'm going to talk today about the way trademark law has evolved over time, and I'm going to focus particularly on an evolution with respect to property and equity concepts in trademark. And for the moment, I'm just using trademark law really broadly. I think you'll see why in a minute. So let me try to give you a little bit of a sense of what I'm up to. There's been a lot of discussion in the trademark literature over the years about the ways that trademark law has come to protect trademarks as property. For most people who write in that vein, this propertization narrative is about a shift from consumer focus, consumer protection focus, to producer protection. Once upon a time, the narrative goes, trademark law aims to give consumers protection against confusion, and it gave producers a cause of action against others who use similar marks for the same kinds of goods and services, but it did so only because those producers happened to be well-situated and highly motivated to vindicate the consumer interests. Adherents to that view typically regard a variety of modern doctrines, many of which allow claims for much more attenuated forms of confusion, and some don't even require evidence of confusion at all. They regard those developments as evidence of a problematic shift away from consumer interests and toward protection of property interests. So as it happens, I've written a lot about that narrative over the course of my career. To put it in sort of short terms, it's overly simplistic and in some ways just wrong. Trademark law has always protected marks as property, and it has always done that significantly for the purpose of protecting the mark owners. What has changed a lot over the years is the way that the law conceives of the property interests that are at stake. So the important shift in trademark law over time was not one from a system focused exclusively on consumers to one focused on producers, or from one that was unconcerned with property to one that's a property-based system. It was a shift in terms of the nature of the property interests protected. But even that revised narrative I've just given you misses some important things that are the result of inattention to changes in the doctrinal structure of trademark law over the course of the last century, specifically with respect to the relationship between trademark law's limits and the broader common law of unfair competition. That relationship has changed a lot, especially in the last 70 years or so. And the way in which the relationship shifted, I'm going to argue, did work a meaningful change in the propertization of trademark law, just a different one than most people have described. Relatedly and necessarily, the same changes have, unfortunately, I will argue, de-emphasized the role of equity in some ways that continue to linger. So to understand what I'm talking about, I'm going to have to give you a little bit of history, and I'm going to start by just talking a little bit about the subject matter of trademark law. That subject matter was once defined in limited ontological terms. As the court in an 1886 case called Davis versus Davis said, a trademark is an arbitrary or representative device that's attached to or sold with merchandise and serving to designate the origin or manufacture of that merchandise. So let me break that apart a little bit for you. On that definition, a trademark was a certain sort of thing. It was a word or a device, which is essentially a logo, and one that unambiguously indicated the source of the goods with which it was used. And by unambiguously indicated the source, what I mean is it was a word like Exxon or a logo like the Nike swoosh that gave no information about the nature of the goods with which it was used. So there was no way to understand why those things would have been on the goods except to assume that they were indicating their source. The example I use of this in class all the time, it makes no sense to put an apple on a computer. The computer's not made of apples. It doesn't taste like apples. It doesn't operate like apples. So the only sensible thing to say is that it must be a brand. And that's the way trademarks were understood. So in addition to being that sort of thing, that certain sort of thing, a trademark also had to be used in a certain sort of way. It had to be separate from and affixed to the goods whose origin the mark indicated. Only trademarks that were defined as such and used in interstate commerce were eligible for federal registration. And only federally registered trademarks could be enforced under federal statutory law. A whole bunch of different sorts of things, different types of indicators that modern law treats as trademarks, at least under some circumstances. So things like surnames or descriptive terms or geographic terms, product packaging. Those things were not trademarks under this more restrictive definition because the meaning of those things was facially ambiguous. They could be used to indicate the source of goods, but they could also be used just to communicate the characteristics of the goods or where they came from. So just to take an example, Milwaukee's Best might indicate a particular brand of beer, or it might just describe in laudatory fashion a company's beer as being the best in Milwaukee. Though as an aside, I will say my college experience suggests that would have been false advertising. Because these kinds of terms were facially ambiguous in the way I just described, they weren't amenable to exclusive ownership and not considered trademarks. But the fact that trademark subject matter was narrowly defined did not mean the law offered no protection against misuse of those other sorts of indicators. Parties that didn't own trademarks, or technical trademarks as they would become known because technically they were trademarks as opposed to something else, those parties could still bring common law unfair competition claims against others who, by means other than using a trademark, attempted to pass off their goods as though they were the plaintiffs. But because those kinds of claims involved subject matter that had plausibly legitimate explanation, courts couldn't just presume the defendant's conduct in those cases was illegitimate. As a result, courts typically required unfair competition claimants to prove that the facially ambiguous indicator, Milwaukee's Best, was likely to be understood as source identifying in the context it was used, and that the defendant intended to pass off its goods as the plaintiffs. Importantly, trademark claimants were not required to prove either of those things. They were both presumed. Prevailing plaintiffs in unfair competition cases also got more limited remedies. These remedies were sufficient to prevent passing off, but short of a prohibition on use of the term or the feature altogether. So a court would not have prevented other beer producers in Milwaukee from identifying their beer as being from Milwaukee, nor would they have prevented them from claiming that their beer was the best. But they would have prevented those other producers from presenting that information in a way that suggested their beer was the same Milwaukee's Best as the real Milwaukee's Best, whatever that is. So to summarize that description, in this legal world that once existed, trademark and unfair competition were conceptually integrated, but doctrinally distinct bodies of law. They were conceptually integrated in that all of unfair competition aimed to prevent passing off. Imitation of another's trademark was just a special case of unfair competition because, as James Love Hopkins, who was a very well-known treatise writer in the 19th century, wrote, use of another's mark is just the easiest method of stealing someone's trade and the most universal, because of the general use of marks or brands on personal property. So all of unfair competition had the same purpose. It was meant to prevent passing off. Trademark infringement was a special example of that because it was an especially effective way of carrying out that passing off. It was in this sense that trademark law has always been regarded as part of the broader law of unfair competition. Trademark and unfair competition were, however, doctrinally distinct in that trademark law dealt with the misuse of a subset of indicators that qualified as trademarks under the prevailing limited definition, right? This definition of technical trademarks, right? Things that were words or devices that unambiguously indicated source, that excluded things that might have had ambiguous meaning, like geographic terms, descriptive terms, surnames. Unfair competition, on the other hand, focused on attempts to pass off by other means, by use of things that weren't trademarks. But importantly, these claims were meaningfully different in that unfair competition claims faced more onerous proof requirements and their remedies were more limited, not to mention that they were using a different source of law. That basic legal structure held through sometime in the middle of the 20th century. But then things started to change pretty significantly in terms of the relationship between trademark and unfair competition. First, courts started interpreting the Lanham Act, the federal trademark statute passed in 1946, to provide a cause of action for infringement of unregistered trademarks. So for any of us who've been trained in trademark in the last couple of decades, what I just said sounds totally unremarkable. We have long accepted that unregistered trademarks are protectable under Section 43A of the statute on essentially the same terms as registered marks. But it's worth highlighting here just how radical a change that was when courts started recognizing those kinds of claims in the 1950s. Every federal trademark statute prior to the Lanham Act made registration available only to indicators that qualified as technical trademarks under that more limited definition. And the cause of action created by those statutes was available only to federally registered marks. Those limitations reflected the deep structure of trademark and unfair competition. Trademark for the narrow class of indicators that could be registered, unfair competition for other things. And the drafters of the Lanham Act did not believe they were changing that practice. But the Supreme Court's decision in Erie left many trademark proponents and several courts concerned about the potential for disuniformity in the law of unfair competition, which had always been conceived of as general law, but which after Erie was suddenly state law. Because they couldn't imagine 50 different versions of unfair competition, courts began to interpret Section 43A to give a cause of action for infringement of unregistered marks. That is, they essentially federalized a significant part of unfair competition as the solution to potential disuniformity. And it's worth underscoring here that courts did that. That was never anticipated by the statute. It was only 30 or 40 years later partially codified by Congress. But I just want to note here the important terminological change that I just made. Courts were not recognizing in these actions a federal unfair competition cause of action. They were providing a cause of action for infringement of unregistered trademarks. I emphasize that because most of the kinds of indicators that were the subject of unfair competition explicitly were not unregistered trademarks. They were not registered because they were not trademarks at all, and they could not have been. But over time, that nuance was lost. Courts largely conflated unfair competition and trademark, and you can see the evidence of that maybe most prominently in the Abercrombie spectrum. Okay, so I won't try to do all of this in detail for you, but what I will say is that anyone who's taken a trademark class or works in the area knows Abercrombie is the most black letter of all black letter trademark law. In fact, if you're only going to teach one case in the entire course, it would almost certainly be Abercrombie. What Abercrombie teaches is that the way we determine whether a claimed indicator is a trademark is by placing it along a spectrum. Generic, running from the bottom here, generic, descriptive, suggestive, arbitrary, or fanciful. You put it in one of those categories. The placement of the term in the categories determines whether it qualifies automatically as a trademark, whether it needs additional evidence, what we call secondary meaning, or whether it's disqualified as a trademark. But what's worth pointing out is that this is presented as the way to determine whether something is either a trademark on the one hand or it's nothing on the other hand. And the spectrum really is a mashup of concepts. Some of the things at the top end of the spectrum, up here, those identify indicators we once simply would have called trademarks. We now call these terms inherently distinctive, and they're protectable automatically simply by virtue of their classification in one of those categories. Other categories, however, for example, the descriptive category, those identify indicators that were by definition not trademarks under previous law. So those things, like Milwaukee's Best, now potentially qualify as trademarks. We just ask their proponents for some extra proof that the term actually does indicate source. And if they have that proof, we pretend those terms are the same as old-time technical trademarks. Conditions for relief in the face of not owning a trademark have been transformed into requirements for being a trademark. The end point of that evolution is the Supreme Court's acceptance in 2 Pesos, a case about the design of a Mexican restaurant, and Qualitex, a case about the color of a dry cleaning press pad. I'll just pause and say, obviously neither of which would have fit in the technical trademark category. The Supreme Court says in those cases that essentially the trademark subject matter is in principle limitless. It consists of, quote, anything at all that is capable of carrying meaning. And when everything can be a trademark, there's really no need for a residual doctrine for things that aren't trademarks. If something doesn't qualify as a trademark, there's a reason. And the reason has to do with its capacity to identify source, not its ontological status as a color or a shape or a descriptive term or a fragrance. Okay, so what I've just tried to describe to you is essentially an assimilation of unfair competition over the course of the 20th century into trademark law. The consequences of that assimilation were largely unconsidered, and they continue to surface in many of the most difficult trademark cases that we're dealing with now. But one thing that's been mostly overlooked is the way the changes increased emphasis on property concepts and decreased emphasis on equity, or if you like, on tort concepts. In the former system I was describing, the major cut between trademark and unfair competition was whether the plaintiff had a valid technical trademark. Trademark law proper then was primarily concerned with questions of validity, whether the plaintiff had a property interest in a trademark. Because the only things that qualified as trademarks were indicators that unambiguously indicated source, there was no legitimate explanation for others to use those same marks for the same goods. Those terms didn't describe the goods. They didn't describe where the goods came from. There was no legitimate explanation. The explanation must have been that you were trying to steal your competitor's customers. As a result, once the plaintiff's ownership of a valid mark was established, the only thing left to determine was whether the defendant was using the same or a sufficiently similar mark. Complicated infringement doctrines were unnecessary. Unfair competition, on the other hand, was at the other end of the spectrum. Those cases, by definition, did not involve a property interest. So in determining whether any remedies should be given, courts were not concerned with identifying the thing the plaintiff owned. They were instead focused nearly entirely on the defendant's conduct. Specifically, courts in unfair competition were asking whether, despite the lack of a property interest in a trademark, the plaintiff should nevertheless get a remedy because the defendant was behaving badly in trying to steal the plaintiff's customers. The doctrine was thick in equitable considerations, the most obvious evidence of which is that the plaintiff had to prove intent to pass off. Because modern law has eviscerated trademark law's subject matter limitations and accepted that anything capable of identifying source can be a trademark, it has transformed cases that once would have been entirely about the defendant's conduct into cases that are largely, maybe even overwhelmingly, about ownership. It has, to put it differently, shifted the balance of property and equity substantially in the direction of property. And that has had a number of important negative consequences. For one thing, it has put tremendous pressure on courts to identify the features of the claimed mark. Many cases that once focused entirely on the defendant's conduct and the risk of passing off have been pushed into a property framework, and that means the emphasis in those cases is necessarily on determining what, if anything, the plaintiff owns. That's a complicated undertaking because the sorts of indicators that have been pushed into the trademark framing have potentially ambiguous and multiple meanings. And they're often complex or compound indicators that include components that are not on their own protectable. So I'm going to give you two examples, both recently filed or resolved cases. Right? So this is a case recently filed by Skechers against Easy Spirit, and you'll notice that the claim is essentially, your shoe looks too much like my shoe, right? So the claim is not that the names of these shoes are similar or the company names are similar. It's that, in fact, the design of the shoe itself is a trademark and this is too close to it, right? But obviously you can see just by looking at it, Skechers can't possibly own all black shoes, nor can they own all black shoes with white soles. What are the features of that shoe that Skechers owns? right? Here's another recent case, right? So Dum Dums sold in this red bag with this clear plastic windows, sues the company that makes charms because they use a red bag with a clear plastic window, right? So obviously, Dum Dums not the only people who sell candy in a red bag, not the only people who use a clear plastic window. What are the features of the whatever trade dress that these guys actually own? What it means is that in cases like this, right, that have been now pushed into the trademark framing, it's critical to understand what's being claimed because you can't evaluate validity without doing that. Courts can't, for example, evaluate secondary meaning or functionality without knowing which features are claimed as the mark, because the answers to those questions might well be different, depending on which features are included versus excluded. Do we include, for example, that there are 300 pops in there when there are, in fact, 300 pops in there? What are they supposed to say? There are not 300 pops in here? Or are we telling them that they're the only ones allowed to sell lollipops in batches of 300? Right? What are we trying to accomplish? Nor can courts effectively manage the scope of any rights in the mark, the range of other uses that will be considered infringing, without defining the mark's features. So these challenges about identifying the nature of the mark are really the result of expanding trademark subject matter to accommodate indicators that once wouldn't have been considered trademarks. Claiming plays a much lesser role in unfair competition, at least as it was once configured. Because the emphasis in those cases was on the defendant's conduct rather than on the property owned by the plaintiff, there was no need to delineate precisely the boundaries of the trademark at issue. There was no trademark at issue, by definition. To be sure, unfair competition plaintiffs had to prove that the defendant intended to pass off, and it had to articulate the means by which the defendant was going to accomplish that. So it's not that unfair competition cases made no mention of the features involved at all. But unfair competition focused only on passing off rather than broader notions of confusion. And so for that reason, the only question courts were asking was whether consumers were likely to buy the defendant's product believing that it was the plaintiff's product. They weren't asking whether consumers might think the two are related, or whether the plaintiff sponsored the defendant, or any of the broader questions modern law asks. That kind of limited liability standard, focusing on passing off, required a level of similarity in order to trigger liability that made deconstruction of the indicators unnecessary in most cases. And probably even more importantly, unfair competition generally denied categorical relief, meaning parties couldn't get injunctions against use of the descriptive word or the geographic term or the design features as such. As a result, the precise identity of the claimed indicator was irrelevant. Conflation of unfair competition and trademark has also led courts to separate trademark cases into fairly formal validity and infringement phases, with the added tendency of making litigation more costly and less, in my view, less accurate. That is, of course, a doctrinal divide between validity and infringement that didn't exist in the former regime because trademark infringement cases were heavily, indeed nearly exclusively, focused on whether the claimed indicator was a trademark, infringement being fairly straightforward once that was determined. While unfair competition cases had no validity phase because there were no marks at issue, and so they were entirely about validity or about liability. Separating doctrines into validity and infringement categories exacerbates courts' difficulty in managing the scope of rights, not least because it encourages claimants to treat their rights like a nose of wax, which may be turned and twisted in any direction, depending on the issue, often interpreted or described narrowly for purposes of validity, but broadly for purposes of infringement. Conceiving of some issues as validity issues and others as infringement issues also means courts really struggle with certain kinds of arguments because they can't place them. And that might be true even though the arguments are substantively persuasive and connected to trademark policies. Let me just use one example here. Manufacturers have in recent years taken to registering the designs of various auto parts as trademarks. Things like this, like the front grills of their automobiles. Sometimes they do that with emblems or logo designs incorporated, but sometimes it's just the grille designs like these. And Customs has begun seizing at the border shipments of replacement auto parts that have the registered designs but are made by companies other than the mark owners or their licensees. So this is a new development. There has been a robust market for aftermarket auto parts for years, a market that has until recently been regarded as entirely legitimate. People want to repair their cars when they've been damaged, and they want to repair them in a way that restores them to their original design as much as possible. They don't want to have to put some other kind of grille on the front of their Dodge or Jeep or BMW. And aftermarket parts companies have for a long time supplied less expensive components that allow people to do just that with their cars. In fact, many insurance companies will only pay, or at least will only fully pay, for aftermarket parts to be used in your repair. And in a good number of states, those insurance companies are legally obligated to use parts of, quote, like kind and quality to the original equipment manufacturers, which they obviously can't do if the replacement parts look different. So one might think that this would be an almost perfect setup for a functionality argument. So according to the Supreme Court, features are functional, and therefore they're disqualified from counting as trademarks when they're essential to the use or purpose of the article with which they're used, or the features affect the cost or quality of the article. The designs of these replacement parts could hardly be more essential to the use or purpose of the parts, and they clearly affect the cost or quality of the parts. In fact, the features seem functional even if we're to consider competitive need, which the Supreme Court has told us we're supposed to do only in a subset of functionality cases. Exclusive use of the designs of these parts would give original equipment manufacturers a significant, indeed a decisive, competitive advantage, since no one would be able to compete with them for replacement parts. So every part of the definition of functionality points toward a finding of functionality and the legitimacy of these aftermarket parts. But when these seizures have been challenged in court, the courts have often had a hard time accepting the functionality arguments. Why? Because courts understand functionality to be exclusively a question of validity. And when they see these parts that are incorporated into new vehicles, courts think, they seem to indicate source, and they don't seem functional in the sense that they're essential to the use or purpose of the car, or they don't affect competition among car manufacturers. Other companies can make grills with different designs and incorporate them into their other vehicles, and they do, and there doesn't seem to be a lack of competition among sellers of cars. The argument about functionality for the auto parts is context-specific. It's an argument about the function of those designs as they are used for replacement parts. And courts don't recognize that kind of argument as being about validity. It's an argument that these designs can't serve as trademarks. It's not recognized by courts as an argument that these designs can't serve as trademarks under any circumstances. It's an argument about whether they should serve as trademarks under these particular circumstances. And because the argument doesn't fit the validity pattern, courts don't know how to deal with it because they think of functionality as a validity question. So something very similar could be said about the role of what I'm going to call defenses, and I'm going to put those in air quotes for a reason, in modern trademark law. So a number of trademark scholars, myself included, have lamented the fact that a number of the doctrines that we call defenses in trademark law don't work like real affirmative defenses. Because many of the doctrines I'm talking about, so things like descriptive fair use, they insulate particular uses from liability only so long as those uses don't cause confusion. And for that reason, they're not conceptually distinct from the prima facie case of infringement, because that prima facie case always requires the plaintiff to prove likelihood of confusion. If the defendant's use doesn't cause confusion, it's not infringing. You don't need a defense. So in that way, these kind of defensive doctrines are different from something like, say, self-defense in tort law. That kind of defense doesn't deny elements of the prima facie case. It doesn't say that there was no intentional contact, or that the contact wasn't harmful or offensive, or that it didn't cause damages. Instead, it just seeks to justify otherwise tortious conduct. Trademark defenses aren't really like that. They're not yes, but defenses. They're more like not really, and maybe it's not so bad responses. And what that means is that it's sometimes hard for defendants to get courts to dismiss cases against them without having to fully litigate the question of likelihood of confusion. And that's a problem because the litigation of likelihood of confusion is expensive and time-consuming. So part of the reason for this state of affairs is that many of these kind of defensive doctrines, and descriptive fair use in particular, are really just awkward restatements of unfair competition concepts that are now being used in some other context. In the descriptive fair use context specifically, the kinds of terms at issue are ones that would not previously been considered trademarks at all. So the discussion in those cases about the nature of the defendant's use and the possible confusion that used to arise in cases entirely as an evaluation of the defendant's conduct, where the question wasn't confusion, but passing off, and where the remedy in any event would never have been an injunction against use of the descriptive term full stop. What we've done now is attempted to bolt onto trademark law, onto a trademark system that treats even descriptive terms as trademarks, equitable considerations from a bygone era. And unsurprisingly, it's not a very good fit. Okay, so I'll do one more here, and then I'll try to wrap up a little bit. So the last thing about the collapse of unfair competition is the important effect on remedies in trademark cases. One of the reasons courts identified certain words and devices as trademarks or technical trademarks was that those things were amenable to exclusive rights because they were the kinds of things that unambiguously identified source and therefore had no legitimate explanation when used by others. The remedies in the trademark infringement cases then followed from that. Because the trademarks unambiguously indicated source, there was no legitimate explanation for others to use them, and any such uses were illegitimate and enjoined. But the kinds of indicators that were dealt with in unfair competition were not amenable to exclusive rights because there were potentially legitimate explanations for those uses. And the remedies in unfair competition cases reflected that too. Courts would not categorically enjoin use of those indicators. They weren't the property of the plaintiff. But they would force changes in the behavior of the defendant to prevent passing off. Remedies might include changes in labeling or in the packaging or use of particular formats or language on the labels. The collapse of unfair competition into trademark has largely cost us that remedial flexibility. We've put all these cases on a property footing, so once there's been a finding of infringement, the court has already found that the defendant has taken something that the plaintiff owns. As a result, cases are much more often now all or nothing. The plaintiff seeks and courts grant injunctions against use of the claimed features, full stop. So in recent years, some courts have started to feel a little uneasy about that. And they've pushed back on what had become essentially a rule that proving likelihood of confusion meant the plaintiff had demonstrated irreparable harm and therefore was entitled to an injunction. And so now sometimes courts have denied injunctions even when the plaintiff has proven likelihood of confusion. But that still is all or nothing. What we've lost is the remedial flexibility that was the hallmark of unfair competition. Courts have largely given up on more limited injunctive relief that would be short of a complete injunction, but might be sufficient to prevent confusion in more limited ways. Okay, so what to do about this? This is the part where I'm supposed to give you some grand solution to the problems that I've described. And given the tenor of what I've said so far, it probably seems fair to assume that I would argue we'd be better off if we just went back to the way things were, make trademark law great again, right, and redefine trademark subject matter in a way, the limited terms that we used to use, and reinvigorate unfair competition, right? That might be and though I might think that, spoiler, I do, I'm actually a lot more realistic than that. We are so far down this road. We're not going to get a complete rollback to the way things were. But there are still, I think, a few things we could do. The first is that there are some areas where I think at least a more limited rollback would make sense. So trade dress, and particularly product configuration, is, in my judgment, particularly ill-suited to trademark treatment. A whole bunch of the most serious and most difficult problems in trademark law, and I should say the most expensive ones to deal with in litigation, are the result of trying to accommodate that subject matter in trademark. And we would, I think, do a better job of respecting the boundaries with other areas of IP by returning to a system that denied protection for product features as such, subject to a more limited set of unfair competition remedies where real passing off was at risk. So, for example, rather than litigating over whether Skechers really owns all slip-on black tennis shoes, we would instead focus on whether consumers would think the defendant was selling Skechers black shoes and order changes, perhaps in name or in packaging or in other advertising materials, to make clear who made those other shoes. Okay, second, even short of completely reinstating unfair competition rules, there are ways of accounting for some of the problems I've identified. Courts could, for example, be more aware of what has happened and be much less rigid about validity and infringement distinctions. They could understand better the origins of defensive doctrines and be more willing to treat them like true affirmative defenses. They could rediscover equitable discretion. Indeed, the statute still tells them to do so. And finally, I think it may be more generally, what I think this is really a call for some serious thinking now about what unfair competition actually is and what it should be going forward. Right now, to be honest, unfair competition is largely a zombie doctrine. Plaintiffs invoke unfair competition in the shadow of their trademark infringement claims, ostensibly as some sort of a backup. And they're emboldened in doing that by comments from the Supreme Court that Section 43A is not a complete codification of the common law of unfair competition, comments that the court then never elaborates on. Usually, these unfair competition claims are entirely duplicative. They're thrown in as a sort of belt and suspenders approach at the end of a complaint. But sometimes they seek to do more than that. So take, for example, this relatively recent case of Bayer versus Belmora and Bayer. In that case, Bayer, who was the plaintiff, owned the Flanex mark in Mexico, which it used for a naproxen sodium pain reliever. Bayer sued Belmora, which had registered and was using the Flanex mark for naproxen sodium pain relievers in the United States. Right? So remember, this is the plaintiff in the case does not own trademark rights in the United States. The defendant does. And the plaintiff has sued the defendant saying, you're infringing by using your trademark that you own in the United States. Right? Bayer's theory in the case was that Belmora violated Section 43A by using the Flanex mark in the United States, even though Bayer admitted it didn't own trademark rights in the Flanex mark in the United States. Incidentally, Bayer sells naproxen sodium in the U.S. under the Aleve brand. So Bayer argued that Section 43A doesn't depend on ownership of a mark, that it gives claims against conduct that causes confusion even in the absence of mark ownership. It's about what the defendant does, Bayer argued, not what the plaintiff owns. So that argument makes a certain amount of sense. Textually, since Section 43A, in fact, doesn't make any reference to ownership of a mark. Incidentally, because it was never intended to give a cause of action for infringement of unregistered marks, but we'll put that aside for a minute. And the argument that Bayer made at least rhymes with old-style unfair competition, which was explicitly available in cases in which the plaintiff did not own a trademark, but which might nevertheless be a situation where passing off was at risk. So it's made a certain amount of sense, and it's sort of echoed with old cases. They had plenty of cases to cite in their brief. Okay. But in reality, what Bayer wanted was the best of both the new and old legal orders. It wanted the benefits of treating Section 43A as if it were a version of old-style unfair competition, so that it could bring a claim when the alleged confusion was caused by something other than use of Bayer's trademark, because Bayer had no trademark. But Bayer did not want the more limited remedies offered by unfair competition. Right? I'll just show you, this was the original package that Belmora was selling in the United States. This is the package that Bayer sells its Flanex in Mexico. By the time the case was litigated, though, Belmora had changed its package to look a little bit like that. I'll come back to that in just a second. Okay? So Bayer wants the upside of treating Section 43A as if it's just a codification of old-style unfair competition rules. It wants the conceptual advantage of being able to say, I get a claim even though I don't have a trademark, because I don't need a trademark. This is a claim about what the defendant's doing, not about what I own. But it doesn't want to focus just on passing off. There couldn't have been passing off because Bayer doesn't sell this product in the United States. So they couldn't have been diverting customers who otherwise would have been buying Bayer's products, right? And they didn't want the limited remedies of unfair competition. Under the old rules, by admitting it didn't own a trademark, Bayer could not have enjoined Belmora's use of the Flanex mark. The best it could have hoped for were limitations on the manner of Belmora's use that would make clear it wasn't Bayer's Flanex. What they could have expected were changes in the packaging and the labeling to make clear that it was a little different. So maybe a move from that box to that box, or maybe even a slightly different. But there's no way they could have gotten, under old unfair competition rules, an injunction against use of the mark Flanex, which is what they actually sought. Because the conceptual history of unfair competition and its relationship to trademark law has mostly been lost through its assimilation into trademark law over the last 70 years, what we're left with is a mashup of ideas and parties that want the best of both worlds. And at the very least, they shouldn't get that. Thank you.
Okay, so we have time for a number of questions, and the way we do this is that if you can signify you have a question, if you're in the lower part of the bowl, perhaps to say, you can use the microphone, and to the extent that you are behind the railing, we have a microphone available for you. So if you can signify you have a question, and we will proceed from there. Yes, is it possible for you to press that down? I would describe to you the process, but I don't know it.
I think I've done it correctly. This development that you've so lucidly described for us, it wasn't just a development, was it, of court decisions? Because isn't it somewhat reflected in the trademark statute as well?
Totally fair question. So I would say overwhelmingly it was done by courts. It's totally right and fair to say that sometimes after the fact, Congress has come along and adopted parts of that into the statute. And that has happened. But it's never happened in a wholesale way. It's usually in sort of piecemeal form. So for example, right, there was no such thing as a functionality doctrine anywhere to be found in the statute. Courts created that doctrine. It's now explicitly in the statute in a couple of different places. It was codified basically following a whole series of court decisions. Congress also codified an understanding of Section 43A that courts had created for 20 or 30 years by changing the language in that statute. But they did that in the late 80s and in the 90s, 20 or 30 years after courts had been doing it. So I think it's fair to say courts overwhelmingly are the ones responsible for these shifts. Congress didn't really push many of them. The only one I think you could say that Congress took the lead on is dilution, but that's, I think, relatively speaking to the kinds of things I'm talking about, kind of incidental. So most of the evolution I'm talking about was really done by courts. That part doesn't bother me because most of the history that I'm talking about was basically common law. Even the law of trademark infringement, which was technically federal statutory law, the statute was really sparse about what was going on. It was mostly developed by courts. So the fact that it was developed by courts in and of itself doesn't bother me. What bothers me is that what courts did was, I think, really out of step with what Congress thought it was doing when it wrote the Lanham Act.
Other questions?
I've convinced them all, it seems like.
I doubt it.
So what you're saying really is that what you have in mind, to go back to, is that unfair competition is about what the defendant is doing as opposed to what the plaintiff owns, which should be in the area of trademark. But you can see, can't you, the practitioner's problem where you're asserting a claim and you want to make sure that you have everything covered, what you own as well as what the other side's doing, so that that's why they end up putting the two together, and then courts being not experts in trademark the way the practitioners are, they'll say, well, I don't see a difference there, so I'm just going to say cut it out.
Yeah, no, yeah, totally. So it wasn't meant to be a comment about the strategy used by lawyers. It totally makes sense to do that. I think what I would say is it's not even necessarily, from my perspective, a problem for there to be a persistent doctrine of unfair competition. But I've been teaching versions of a trademark class for 16 years now, and every time at some point one of the students will say to me, like, what is unfair competition, right? And I'll be like, I think it's a claim that you put at the end of your complaint in case you lose your trademark infringement case, but the court thinks they're doing something bad, right? And so they just want to kind of, that's why I think what I was trying to say at the end is what we need is some conceptual clarity about what unfair competition is and what it does, right? And by basically emptying its contents into trademark, but then sort of letting it linger out there, to me it seems like now it's basically exerting some kind of gravitational pull but has no content to it, right? And so if it's going to exist and it's going to continue going forward, we ought to have a much clearer sense of what unfair competition's role is vis-a-vis trademark law, and it shouldn't just be a second bite at the apple. Right? It should have some actual conceptual distinction between it.
Thank you. Other questions? Oh, I'm sorry, I did not see you. Please.
Okay, so though you did not pretend that we were in a perfect world and we roll back to a clear distinction between trademark and unfair competition, you did suggest maybe some changes that would reinforce unfair competition as a distinct doctrine. What do you think would be the ramifications of going in the opposite direction, of entirely getting rid of unfair competition as a distinct doctrine and just having trademark?
Yeah, that's a great question. So that's obviously the other possible alternative is just say, well, listen, you've assimilated unfair competition into trademark, so just do it, right? Do it completely and just say unfair competition's gone. Okay, so there's a couple problems with that. One is there are the parts of unfair competition I've been focusing on here are the parts that are sort of trademark-like. Unfair competition does also recognize some other kinds of claims that aren't about use of a trademark, but sort of exist in this parallel universe. It's not, I would say, sort of related to the last question, it's totally unclear to me what makes that constellation of things hang together as all belonging to unfair competition, as opposed to just being other things that are available out there in the universe. So what you could do is say, like, forget, McKenna's crazy, like, let's not try to go back to unfair competition. Let's just say, hey, unfair competition is a historical doctrine, it's gone, right? But I think we would lose some important things for that. At least what we ought to do if we do that is say there were some smart things about unfair competition and the way that it thought about remedies and the way that it thought about different kinds of uses. And if we're going to do that, we should at least be smart about the history and understand that, like, things like defenses that we have now. So the Supreme Court basically gets a case, a descriptive fair use case, and it says, well, it can't be the case that the defendant has to disprove confusion in order to prove a defense. That would be crazy. Otherwise, it wouldn't be a defense, right? Which totally makes sense. Except that then they turn around and they say, but, on the other hand, like, the amount of confusion is probably relevant. We just don't really know how much, or we can't tell you. And so you read these cases now, and it's just kind of courts are being like, yeah, I don't know, it seems like too much. Maybe, nah, right, not so much. I just don't think we can have the kinds of defensive doctrines we have now without some reckoning about unfair competition. So either we need to actually say, no, we're going to just create a set of affirmative defenses that don't have any connection to the prior unfair competition doctrine, or we need to do some disentangling. So I think it's entirely fair to say you could do either of those things. I think we would be worse off just saying, let's get rid of unfair competition altogether. But if we're going to keep unfair competition around, it needs to mean something, right? It has to have some content to it.
Let me ask a question. Is it available to eliminate unfair competition? It would take some authoritative act, not the current statute, I presume.
Yeah.
So the rulings of 50 different state courts?
So I suppose it's a complicated question. On the one hand, you might say jurisprudentially, like no single court can just say, hey, unfair competition is wrong. It's gone. On the other hand, collectively, that's kind of what they did over 50 or 60 years.
Well, that's what the federal courts did in interpreting the federal act. It's not what the state courts, I take it, have done in interpreting their own law.
So there's sort of a parallel talk that I could have given, which is also that one thing actually many people who are trademark litigators know too is the other sort of parallel development that's happened over the last 100 years is there's no more state trademark law. There's basically, it exists, but it exists in name only, right? Virtually nobody brings a you put the state infringement action in your complaint, but then a court just says, oh, that's the same as the federal one, right? And the only exceptions to that are circumstances where a handful of states have like gone further in dilution or something. So state law has been largely vacuumed away, and for similar kinds of reasons, right? Which is that state law was kind of like residual to the things that weren't registrable federally, either because they weren't used in interstate commerce as previously understood, or because they weren't the kinds of things recognized as trademarks. So there was a body of this stuff. But the thing is, if you read those old cases, courts never say, we're applying the law of Illinois. They just say, this is an unfair competition case, right? They thought of them as general law cases, and then Erie came along and they were like, whoa, I don't know what this is, right? I guess, but not surprisingly, they had a whole series of cases they decided before. They weren't going to just junk those and say, well, now let's see what the Illinois Supreme Court says about it. So overwhelmingly, state law doesn't really meaningfully exist. So how would you get rid of it? Well, one thing you could do is I think Congress could just say, given the breadth of the modern Commerce Clause doctrine, and given what's happened with 43A, 43A is a complete codification of whatever's left of unfair competition. It preempts anything else that's out there. Done. Now that would require Congress being functional in some important ways, but so that's entirely possible. You're right, it's a lot more complicated for courts to do it because the status of what unfair competition law is, given that some of it's kind of smushed into the Lanham Act, I think is a little unclear.
So that's my best effort to convert this into a civil procedure lecture. I did have help, though, with the reference to Erie.
Yeah.
You opened the door for me.
I have another paper for you on that.
Thank you. I appreciate that. So here's what I would like to do. We will have a reception in the Zilber Forum, and I encourage all of you to stay. If you have other questions that you want to press upon Professor McKenna, he will welcome them, I'm sure. I want to thank all of you for being here this afternoon for our annual Nies lecture, and especially on behalf of all of us, I want to thank Mark McKenna for coming to Milwaukee, reliving his college days, perhaps, with the reference to Milwaukee Best.
There will be Milwaukee's Best.
That was well played,
so,
and enlightening us with this lecture. Thank you.